Hello, it's Shade. Welcome to our Freebie Friday video. Today we've been asked to go over how to get an agreement in writing when one party is relinquishing all rights to real estate. So the kind of situation we're talking about is not when both names are on the deed. It's a situation where sometimes there are both names on the deed, and sometimes the other person's name is not on the deed, which is the title, the official title to the real property, but they may potentially have claims, legal claims that they could bring against you to try to get some part of that property. So if that person has agreed to you informally and said, listen, I don't want any part of it, don't just take the verbal agreement or text message or email as word, because when it comes to real estate, everything has to be in writing, and it has to be in some form of official writing. So can you then sit down at the kitchen table and put together a two-sentence agreement between yourselves? Yes, you can, but it's not really sufficient in terms of title companies, realtors, and lawyers and courts and things like that. So I would advise that you use something called the affidavit of disinterest. The affidavit of disinterest just says that I, Sade, don't want anything to do with your property that you have. So I can say I'm not interested in it, meaning that whatever interest I do own, it doesn't mean that I own interest, but whatever interest that I do own, I don't want anything to do with the property. So get that in writing. If you're able to put it together, I don't think there's any form out there that per se that's used, but a lawyer can help you with it. But if you feel confident that you can put it together, you can go to the law library and try to put something together. Make sure that you have both names on there, because that person you'll be listed, you should list that person that's going to sign it, which is the other party that's given up their ownership or whatever ownership rights they may have potentially. And then you should have your name in there as the person that they will relinquish all their rights to, as well as make sure that that other party is the one that notarizes the document. You don't have to sign it, you don't have to notarize, but that second party definitely has to notarize that document. And I would suggest that you file that into the property records as soon as it's signed. Don't just hold on to it, because then it's not really of record for everybody else to see, and it's not really quite official when you just hold it. Plus you might lose it. So file into the property records. Inside that same document, you have to identify the property by property address, if it's a physical address, if it has a physical address. But you also have to put the legal description of the property, and that legal description is very specific. It's inside your deed documents that you already have, but it's not the same as the description that's with the county's tax office. The county's tax office usually uses a very short version of the description, so that's not sufficient. Just so you know, if you don't know where to find it, get help, and somebody should be able to help you with that. So that's our advice to you today. Of course, as always, it's for educational purposes. Always get legal counsel whenever you need help. And if you think that you're stuck or don't know what to do next, definitely reach out for help. So I hope this is helpful to you in some way, and send us your questions always, and we'll continue to do the videos every Friday. So happy Friday, and talk to you next time.